Presentation is the use of force in international law. The use of force by states is prohibited under international law. To understand this law, we must look at the sources and their practical applicability, i.e. the cases which illustrate it. The use of force by states is controlled by both treaty law and customary international law. Let us first look at treaty law. We can find this law written in the UN Charter, Chapter 1, Article 2, Paragraph 4, and states that all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state or in any other manner inconsistent with the purposes of the United Nations. The words territorial integrity and political independence are very important. The former emphasizes that states should not attempt to promote movements or to promote secessionist changes in other nations. Political independence emphasizes the importance to preserve the right of self-determination, which is mentioned in the Chapter 1, Article 1, Paragraph 2 of the United Nations Charter. There are two main factors which cause the development of this law. Firstly, the Kellogg-Briand Pact of 1928, which is a multilateral treaty that prohibits the use of war as an instrument of national policy. This pact is an important multilateral treaty, firstly because it binds the particular nations that have signed it. Secondly, it also serves as one of the legal bases establishing the international norms that the threat or use of military force in contravention of international law, as well as the territorial acquisitions resulting from it, are unlawful. Until today, this treaty remains binding under international law. Yet, it has not shown to be this effective. For example, the Japanese invasion of Manchuria in 1931, or the German and Soviet Union invasion of Poland in 1939. Many people argue that the law is written as a lesson learned from World War I and World War II. The preamble of the United Nations Charter also specifically states that, I quote, "to save succeeding generations from the scourge of war, which twice in our lifetime has brought untold sorrow to mankind." Now, let us move to customary international law. The prohibition of the use of force has become customary law based on state practice and opinio juris. Opinio juris means what states think the law is. Examples of opinio juris can be seen as the Kellogg-Briand Pact or the United Nations Charter, Article 2, Paragraph 4, which we saw earlier. Examples of state practice can be seen as decisions of the ICG, for example, the case of Kuwait versus Iraq or Nicaragua versus the United States, and many other situations. This law has also developed into jus cogens, which means a compelling or higher law which cannot be overridden. Finally, we can also learn that from the ICG decisions in a case like the Nicaragua versus the United States, humanitarian aid is not considered as a use of force. Finally, treaty law and customary law are mutually exclusive. This was also demonstrated in the Nicaragua versus the United States case, where Nicaragua had asked for a reservation for all multilateral treaties. The court, however, decided that customary law was mutually exclusive from multilateral treaties and thus could be a valid legal obligation against the prohibition of the use of force. This law also has exceptions which allow the use of force, which we shall see now.
So the part concerning the exceptions to the prohibition of the use of force will be divided in three parts, and we shall first examine the right of self-defense, or what is also known as unilateral self-defense, which means when one state takes action against another state. Then we shall take a look at the mean of pacifying conflicts, which is the use of collective self-defense and which has been advocated by the United Nations. And thirdly and finally, we shall examine the role of the Security Council in prohibiting the use of force or giving the capacity to use force to certain members. The part concerning unilateral self-defense. So the Caroline case in 1837 concerned an incident opposing the British and the American, and in it were defined the customary rules for self-defense, which were based around three main points. The first one was that the repercussions must be proportional to the attack to which the country has been a victim. Secondly, it should be a necessary attack. And thirdly, it should be an immediate response and not be delayed. The right to self-defense is also mentioned in the Article 51. If we take a look at this article and if we briefly read it, it says that nothing in the present charter shall impair the inherent right of an individual or collective self if an armed attack occurs against the members of the United Nations, until the Security Council has taken measures necessary to maintain international peace and security. So a couple of situations which this allows is, for example, if a country is victim of an ongoing armed attack, such as was the case, for example, in the case concerning Iraq v. Kuwait, when the Iraqi forces were invading Kuwait, and what happened, Kuwait sent its army to intercept them. Then there was also the armed attack which Israel anticipated in what concerns Iran. The Israeli launched a strike against an Iranian nuclear reactor which was said to be aimed at Israel. If we take a look at the right to anticipatory self-defense, it's a subject which creates much controversy. If we take a look at the famous British scholar Ian Brownlee, according to him, the United Nations Charter eliminates the right of anticipatory self-defense, and it only gives the right to self-defense. Whether other countries such as the United States or Israel have argued for the right of anticipatory self-defense in the past 2 decades. And now we shall take a look at what is referred to as being collective self-defense. It is also known under the name of collective security, and it mainly refers to the use of force on the behalf of the international community and not by one isolated state. During this kind of situation, very often an international organization will act as the umbrella under which collective self-defense is organized. So, if I may say, it plays the role of the UN, but instead of playing it on a global scale, it plays it on a regional scale. If we take a look at what happened around the world after World War II, the North Atlantic Treaty Organization set up a defense treaty amongst neighboring Anglo-Saxon and European countries, Canada, UK, against the communist threat. If we take a look at the Baghdad Pact, the Rio Pact, and other pacts such as the Manila Treaty or the ANZUS Pact or the Washington Treaty, they all mention that, for example, parts of the world such as Pacific Asia, Japan, the Middle East will be protected by the communist threat by American troops. And then if we take a look at state practice, there are the 2 cases which actually show in a way that these forms of collective self-defense are efficient. If we take a look of Kuwait versus Iraq, where the international community supported Kuwait and its retaliation against Iraq, and there's also the more recent case of the 9/11, where actually many governments gave troops in order to organize a form of what is called collective self-defense against a non-state actor, which was Al-Qaeda. And this mean of resolving conflict is not widely used, mainly because very often when a problem attains such a magnitude, it is dealt by with the Security Council. And the Security Council is an organ whose role is fundamental in maintaining international stability and security. If we take a look at the United Nations Charter, and Chapter 7, Article 41 states that the Security Council can create or implement sanctions against a country which is not willing to cope with its demands, and this makes reference to the fact that use of force must not be mobilized. So this means that they can freeze economic relations, install trade barriers, or other type of sanctions. However, there is the Article 42, which says that if a state does not comply to what the Security Council says, then the Security Council can use force in order to make this country comply with its demands. And in the case of collective self-defense, or also in the Security Council granting rights to other states to mediate or to act as actors in a conflict, is given by the Security Council. And if we take a look, for example, at the Grenada crisis in 1983, an organization concerning the Eastern Caribbean states was allowed to resolve this conflict instead of the United Nations and the Security Council having to intervene.
To sum up, although in international law the use of force is prohibited, certain conditions such as the unilateral and collective self-defense or the Security Council's approval render it justifiable. The irony to note is that although the prohibition is a treaty law in just cogence, not all states abide by it.